So, Bibek, you obviously do a lot of different things, which is one of the things I've always enjoyed working with you. You do closings, you do some landlord tenant law, like we described. Tonight, though, we're going to be talking a little bit about due diligence, the tips and tricks for due diligence, and we just got a couple of like general questions for you to kind of just have a conversation about this. But let's say that you're a newer investor, maybe no property is one property. What are some documents or some things you should be asking for when you first put a property under contract as a new investor?
Okay, thanks, Jen. Yeah, that's a great question. I think, I'll work a little bit backwards just so, for people who are not totally familiar with just even the transactional process. In Illinois, you can go in, you're working by yourself or you're working with the broker, you identify a property, you know what you want, you locate it. So, some other states, you actually do the inspection and things before you actually sign the contract. In Illinois, you sign the contract, and customarily, it's usually a 5-day inspection attorney review period, which I guess you could call the due diligence period. Now, today, I guess I'll focus on, we won't talk about like single family houses you're buying for yourself. We're talking about investment properties, right? That's what everybody's here for. So, but some of this can go hand in hand with what you're doing if you were to purchase a home on your own as well. So, when it comes to the inspection period, attorney review period, you've got this 5-day period in which you can modify the contract, request documents, and ensure that you really want to go into this contract. That's your time to either get in or get out at no cost, right? So you have earnest money you put in. That earnest money is fully refundable if you terminate during that five-day period. By the way, it's a 5 business day period. Does not include holidays, does not include weekends as well. So, so during that time, and sometimes John is a great broker, and I'm not just saying that just to be nice. John, as a broker, works with his clients and gets a lot of these documents before I even get involved, sometimes for him, requesting, leases and things like that. But generally speaking, when I'm doing a modification letter and when I'm going into a transaction, you tell me, hey, hey, Bibek, hey, I just signed a contract for a 3-unit. The first thing I'm going to do is I need to make sure that along with the broker, make sure that your inspection set up, make sure you've got that aspect of it. But then I'll focus on like the tenancy issue. So items that I request right off the bat during the modification period and for your ability to review them is leases. Make sure you got copies of all leases, or if there are no copies of leases, you want estoppel letters. Estoppel letters are things that are signed off and notarized usually. Sometimes they don't notarize it, but depends. Is a form that I, as the attorney, I prepare, but usually give to the other side that discloses that's to the tenant stating, this is legitimately my rent. I've lived here since X date. I have a security deposit. I don't have a security deposit. I pay utilities. I don't pay utilities. And it's signed off by the tenant and the seller is given to you, okay? So that's in addition to the lease. And sometimes you won't have a lease. Sometimes there's tenants, you're going to be disclosed, hey, I have 3 units. They're all month to month. These people are great people. They pay me in cash. Wonderful. You've got people you're buying from that are really astute, very good, run their business well. And it is a business. That's what this is. At the end of the day, owning a real estate, 1 unit, many units, it's a business. You got, the best thing I can advise my clients is, run it like as well as you can. Keep on the things as it relates to the tenants. Make sure you keep your documents in shape. Make sure you keep everything documented too. Things like agreements that you make with the tenants, if you modify leases, etc. So again, you're going to ask for an estoppel letter. You're going to ask for the leases. If there are no leases, you're going to get estoppel letters in lieu of that. Additionally, you're going to ask for rent rolls. So not every landlord is great about this that you may be buying from, but generally speaking, most, if you're buying from a landlord who's good and a student and has lots of properties and been doing it a while, they have rent rolls. Rent rolls are what tells you, hey, what money was coming in and out from the tenant? Are they back? Are they delinquent on rent? Do they have late charges, et cetera? So that's what a rent roll is. lot of properties you may purchase may already be managed by a management company or property manager, and they have like kind of rent rolls that are built into their programming, and so you can get it, you can see what's going on with that tenant. Okay, so those are things that I ask for. Other things that I ask for is utilities. Who pays utilities? Like, does a tenant pay utilities? Does a landlord pay utilities? What's included in utility? What's not included in utilities? So there's some other details. So you know what you're in for, right? Like water bills are a big deal. You don't know, like you can get stuck with water bills. You're getting in and you realize that there's like a water leak, and then you've got these high bills, and it'll tip you off. Hey, why are these water bills so high? So those are things I ask for, just so you know ahead of time what you're getting into. You might not pick that up on an inspection, but all of a sudden you're seeing you've got all these crazy charges on these utility bills. Other things I talk about, it depends on the property, but like, is parking included? Are they itemized? Are they in the lease? Is parking assigned to a certain tenant? Is there a unit? So those are things that can come up, because you might take something on and you'll get a tenant who's like, hey, yeah, that always used to be my parking spot. And you're like, what? That has nothing to do with you. You're not, I don't see anything on here that says that you have that parking. So, things that you want to kind of see ahead. You're inheriting all this. Nothing's going to be perfect. You're going to have issues. That's just the name of the game. And your job during due diligence is to nail down all the things and know what you're getting yourself into. That's what it's about. I mean, it speaks for itself. Other things that I also make sure that it will be contained in your estoppel letters, security deposits, depending on what jurisdiction you're in. If you're in Cook County, or if you're in the outlying suburbs, those are things that you want to be sure you make sure of, that you got security deposit, how they're covered. Okay. So those are kind of like all the due diligence items. I think John was trying to ask me a question.
Yeah, Bibek, sorry, my connection was off there. So sometimes I work with people in Chicago, and sometimes I work with people who are working the burbs, buying a property. How do you handle zoning? Like, I know Chicago has a very specific zoning process, which is kind of funny, like figuring out how many apartments there are in a building. And then obviously the suburbs have like a totally different process, each one. So some of them have like a pre-sale inspection, some of them don't. If you're an investor, what are some things to look out for? Maybe talk about Chicago first, and then talk about the burbs.
Yeah. You're right, and they're very various things. So I'll talk about Chicago. So if a building is under 6 units, you got to get a zoning cert, right? And so what you're going to get, you're going to buy a 3 unit, and pretty common you're going to see in Chicago, where somebody's converted a basement, right? And they're like, oh yeah, I got a 3 unit. I promise you, it's 3 units. It's all good. It's wonderful. Like, no, that basement was never converted. And I've seen this. I've had closings happen, and it's wacky. It's the city of Chicago. They're going to do what they're going to do. So before closing, customarily, if you're going through the transaction process, the seller discloses to you, to their best knowledge, that, oh, this is a 3 unit, but they're not the ones who are certifying that. Ultimately, you're going to need a zoning cert that's conveyed to you prior to closing. So before you ever close, you definitely want to make sure you're getting zoning cert. Now, if it's a single family home, that's cool. That's fine. That's easy. You just get a 1 zone. You don't even have to worry about it. You'll get it at closing table. But if it's more than 1 unit, you have to ensure that you get a zoning cert. And I've seen ones where the person, I represent a client, bought a place in 2018, had a zoning cert that was conveyed to them from the city, stamped, signed off, certified, 3 unit. The zoning certs expire, by the way, within 1 year, so they're only good for a year. So 3 years later, hey guys, Bibek, we're going to be selling this property, and I verify, hey, how many units was this? Okay, great. And I submit my paperwork for the zoning, submit it to city. I get it back. It's 2 units. I'm like, what are you talking about? Like, this is 3. I even have a certificate from 2 years ago. No, my predecessor screwed up. He should have looked at the water cert from like 1956 and it's actually really a 2-unit. This is not a 3-unit. Here I am the day before closing with this situation, and it was kind of during COVID or right after COVID. So zoning certs were coming in very late. So you get submitted, and if it's more than 1 unit, City of Chicago was taking like 3 to 6 weeks to get it turned around. So it was a big pain in the butt because you have a closing date that was preset, and then you're sitting there waiting for zoning. And yeah, that's a lesson to be learned, by the way, is, I've taught my clients, it's like, do not close until you have that zoning cert, because it could come back. Even if they said it's a 3 and they could come back as a 2, devalues your property, and then you've got to deal with that headache, right? And you've got somebody who's living in essentially in the illegal unit, right? So that's, Chicago in a nutshell, that's what you're going to get. The seller always provides a zoning cert. John, you're like probably better versed than I am. Like, Berwyn has it. You have pre-sale inspections. Bolingbrook, for example, I just did a closing in Bolingbrook. You have to call in to verify the zoning before, and you fill out the real estate transfer stamp before you can get the transfer stamp. So in order to go through the closing, in order to get a transfer stamp, you don't necessarily need it in Cook County. You don't need a certificate of zoning. Most title companies will require it for a purpose of underwriting it and insuring it, as well as lenders. But other jurisdictions might require it, where you have to call in to verify it, verify the zoning, etc. So there's so many different ways that it can go about. I didn't want to Berwyn's one that has a pre-sale inspection. You have to get all those certificates, and you have to do all of that fun stuff that I'm sure John's just loses his mind.
Each town is different, right? That's what drives you insane. Even like, for instance, LaGrange has nothing. They don't have any pre-sale.
There's no zoning requirements.
Yep. Zoning, you just close. Whereas other towns I've worked in have their own little nuance to that, and everyone's different. So that's been your experience as well as an attorney. You really have to focus on what each town does. So you
Correct.
Get yourself in trouble. Don't close your attorney review until you kind of know you're good on the zoning end of things.
Yeah. And you can close attorney review. So what I do, I always have a catch-all in my attorney review letters, like seller to provide zoning by closing, or verify the zoning, it's zoned as a 3-unit or whatever. And I want their answer. What are they? You want it from them. At the end of the day, I think we were in the breakout room, what we were talking about is like getting things in writing. Like, one of the most important things I always say is like, oh, they could have told you over the phone. Oh yeah, hey man, I'll sell you this property. Oh yeah, it's definitely 3-unit, man. Don't worry about it. Like, get that in writing, because it's a seller representation at that point. And so, if something goes sideways and the zoning is wrong or something, you've got some teeth to go after them, because technically that could be a devaluation of your property, right? You had a 3-unit, now you have a legit 2-unit, right? So, that's things that you do during due diligence, things that you should request, things that the attorney should know to request these things. I've seen some things that I get calls for litigation stuff when things go sideways. So I see probably the worst of it, but most often than not, most of these transactions go smoothly and it's not an issue.
Vivek, a quick question. So I know this might be an anomaly, but for the guy who did get the zoning cert and ended up getting changed, like, that's not something that was missed in due diligence, right? That was just a mistake. So his property was devalued. Nothing you can do about it.
Even in that scenario, we had the zoning. I was a seller. I disclosed to the other side during attorney review, yes, this is a 3-unit.
Right. So a mistake from some random city employee.
We don't warrant it, but I said, to the seller's best knowledge, it is, because the seller's knowledge is that, right?
Right.
So that gives the seller a defense. If somebody was to sue them and be like, you sold me this telling me it was 3, and it's like, oh, look, to the best of my knowledge, I had this piece of paper that told me it was. Right? So that protects that seller. So in essence, I was protecting the seller, and whenever I do attorney reviews from the sell side, depends on which side I'm on, right?
Yep.
I on the buy side, I want to make sure that I'm asking these questions and getting it in writing. And if the seller's like, I don't know, I could be a 2 or a 3, then at least we fronted that issue right then and there. And now during due diligence, we could deal with it, right? Does that mean a reduction in purchase price? Does that mean there are various things that you can do to deal with it, right? Even if there's a property, for example, that is a 3-unit, and you're taking it on with an illegal basement unit, there are a lot of buyers like, this is still good value. I'm going to take this on. I don't care. It's good for me. I'm good. Or like, see if the seller will knock $5,000 off. It happens all the time. So, but you want to make that decision. So, yeah, I mean, that hopefully that answers your question, but
yeah, definitely.
yeah, you can't, seller's not going to know every single aspect of things. And I know John's about to ask me a question about that. So go ahead, John.
Vivek, I know when we were kind of prepping for this, we talked a little bit about how physical inspection plays a part of due diligence as well. And obviously, you as the attorney, you're not doing a physical inspection on a property. If you're a buyer doing due diligence, what part does physical inspection play in attorney review? Like, how do you look at physical inspections from the attorney's eye?
So I do a lot of closings, and I will tell you this much: I have zero clue what the property looks like. More often than not, unless I go to look at the listing for my own fun. But I'm looking at legal paperwork, period. So I have no idea. I'm relying upon the inspector and the buyer to notify me, hey, Bibek, I went into the property and the ceiling was coming down. Well, you got pictures for me? I'm going to convey this over to the other side, tell them, hey, this is what's going on, right? So I know sometimes I'm not like trying to defend attorneys here, but like kind of when everybody's like, oh, I hired my attorney, he knows all. Like, trust me, we don't know everything. So we can fake it sometimes, but we rely on the inspector. So like that's really one of the most important things is you should attend your inspection if you can. I know a lot of people don't have time, that's fine, but even for my own home purchase, I learned this just by being an attorney. I took my time off. It was in the middle of the day. I didn't go to work, and I was like, screw it, I'm going to go. I'm going to walk around with my inspector, because my inspector, like, yeah, he's going to note things, but he might see things and be like, by the way, there's not an issue here yet, but you're going to have this issue come soon, right? And it's good to walk through a property and understand it and know what's going on. So, when you're asking during due diligence or during attorney review time, you're going to ask for repairs. Ultimately, you're going to be relying on that inspection report to be tendered to the other side saying, I want you to do X, Y, and Z repairs because this is what came up on the inspection report. Just because, like, the inspectors, one, they don't always look at everything, okay? I know there's some inspectors who are like, all the windows are great in this property. Well, I know some inspectors who check one window a floor to verify that all the windows, which is ridiculous. But, what are you paying them for? But when you're paying some inspectors $300, $400, you get what you paid for, right? So, so that's something to, be wary about. You definitely want to go through the property. You want to, if you can get as many opportunities as you can to walk through the property, do it. And then, as I was saying, during attorney review, I usually get a punch list of items. So I ask the buyer, here's your modification letter. It's done. I just need to know, what are you asking for repairs? What came up? Or, maybe they'll email me immediately, be like, this property's horrible. I got to get out. That's when we can cancel. Inspection came back bad. Fine. Best $400 you ever spent, right? You're out. You're not hankered with a bad property. So, you're going to get the spreadsheet. I'm going to get a list, and under 7.0, we're technically not allowed to tender it to the seller, but unless they ask for it. But ultimately, whether they're going to do repairs or give credits based on repairs and things like that is going to come down to that inspection report. So all that other side item that I was telling you that you're walking through with your inspector and you point out, you're not going to be getting those during attorney. You can bring them up, but like most sellers are probably not going to give you credit for things that are just not an issue yet. Again, in due diligence, also, it's important to remember most real estate contracts are pretty clear that it has to be a substantive item that just because an HVAC is old, if it's working for its intended purposes, you can't really technically ask for that. People do, but just because it's 20 years old and it's still working and chugging along, you can't be like, hey, it's 20 years old, I want it replaced. No. I mean, there are other options. You can't warranties and things, but still.
Vivek, if you're a seller, do you want to see that inspection report, or do you not want to see it?
Case by case basis. I mean, most sellers know the issues in their property, right? So once you get the inspection report, and this is why the 7.0 has that language. Now, it doesn't applying some of the multi-units, the Chicago realtors contracts and stuff, you can still tender them. But technically, let's say somebody tenders this year and you guys are now like bickering with the buyer and the deal falls through. You now have a written disclosure in your hand telling you about this issue. So now you're about to sell to somebody else and you actually have knowledge of a known condition in your property. Whether it's significant or not, the law is a little bit gray about this, whether, an inspector is not a specialist, right? He can be like, oh, I think there's a foundation issue. Do you have to really disclose that to the next coming buyer? Like, unless you got a structural engineer specialist report, I'm err of the no. If you're on the seller side, no. Let their inspector go in and do their inspection, see what they come up with. But again, case by case basis. I mean, most sellers probably know the condition of their property, and usually this is where I like lean on the brokers. Like, hey, I got this request from the other side. I might reach out to John. I got this request. They're asking for 20,000 repairs. Like, can you pick up the phone with the broker? And then the broker will be like, oh, the roof is collapsing. And John will call me up. I'm like, yeah, we're not asking for that report. Like, nope, that's the one I don't want in writing, right? So like, no, I'm not asking for that report. So that's a good example of sometimes where you're just like, no, I don't want to know. And then let the next buyer try to determine what they have or issues they have with the property. So
Bibek, you referenced the 7.0 a couple of times. I'm going to guess that those who aren't brokers are not familiar with the multi-board 7.0 contract. Do you want to just tell all the lay people out there what that actually means?
Oh, well, so there's a standard Illinois created with the Realtors Association. It's called the 7.0 contract. So essentially, all contracts are pre-made, essentially. So at any time, by the time you hire the attorney, the contract already exists. You didn't hire the attorney to make the contract because it already exists and they've gone through this rigorous years of the changes, et cetera. So you have various Main Street organizations, a version of a multi-unit one, and they have its pre-printed language. Every time I will always tell you, make sure that contract always has an attorney review, because if it doesn't, then you're going to have you want to at least have that 5-day window to get the heck out of that contract. That's you're just like, let me get out of it. So you may see various contracts. There are developer contracts, or self-made. There are other contracts. There are assignment contracts. So I've seen all different various contracts. The 7.0 is probably the one that's most commonly used. You're going to see those more in your general like home sale purchases when people buy their houses and sell their houses. I do see them a lot in multi-units. There should be a rider in the multi-units, and it doesn't really have too much about multi-units, but again, that's what the attorney modification provision is for. And so like, that's when I jump in and I'm asked those questions of things that I would expect to see. So then you've got other contracts like condominium contracts, which have condominium riders and things that you'd ask for from a condo board. So the 7.0s, it's a decent contract. It covers up most of your basic bases, but like, yeah, for an investor, depending on the jurisdiction, not always the greatest unless it's like single family houses. But if you're gonna definitely have a multi-unit, you should make sure that there's a rider. I know a lot of brokers don't necessarily put the rider on or check it off or check off the box. And I find out like halfway through attorney review that I'm like, wait, what? I thought this was a single family house. Wait, there are 4 units? Oh my God, I gotta ask for all this. So at least make sure your attorney.
It's tricky, right? And I think a lot of residential agents don't know about the rider. So I actually go back and forth. Sometimes you need to get the darn thing signed to get it to the attorney so you can have an attorney review. So it's tricky.
Yeah, and as long as the broker and the buyer just let the attorney know, hey, here's the contract. By the way, we were racing to get to sign. Just can you make sure that, hey, we got to get leases or whatever. That triggers to me as an attorney, immediately triggers like, you're like, leases. I'm like, oh, whoa. Okay, how many units is it? I'm going to probably ping you with a slew of questions about things like, is it fully occupied? Do you guys know? And those are questions I'm going to ask also in attorney review, but from the buyer end, yes. But again, even on the seller end, I've got contracts that just pop up in the middle of the night. I'm like, oh, great, wonderful. And then I find out like, halfway through, I'm like, wait, they're leases? Like, oh my God, I need a rent roll. What's going on here?
So Bibek, getting towards the end of our presentation part of this here before we have some Q&A, I'm sure you have a ton of good like war stories or like biggest fails or biggest misses during due diligence. Why don't you just tell us one or two? I mean, you don't have to name anything like that, but one or two like, wow, strikeouts. You're like, wow, if they don't
So
do
let me
one
start
thing.
with some of John's transactions.
Yes, let's do it. Let's do it.
I kid. Biggest misses. Well, I mean, I did cover like the topics generally, so they came from experiences I've had. One thing, I was heavily involved in some litigation with the city of Chicago representing investors from out of state. And like sometimes you got to go with your gut, but people were being taken advantage of. Essentially, there was people who were scamming here, selling properties and offering $1,500 to not do an inspection, telling the other party, telling the buyer, I'll give you $1,500 for you to not do an inspection. And lo and behold, I get hired like a year later, 2 years. Oh, I'm stuck in housing court. They're going to demo my property. Like, and I'm like, well, what happened? And like, did you do an inspection? Did you know about this? Did you ask for this stuff? And no, I didn't hire an attorney. I didn't do any of this. Like, buyer beware, man. Like, it's one of your biggest investments in your life. Like, I don't get it sometimes in my mind, and I see this a lot where people penny pinch over like $50 or $100 here or there on probably one of their biggest investments in their life. I'm just saying, even from like a general post, most people buy what, 3 or 4 houses maybe in their whole life. And you're going to shortchange the inspector and the people that are doing this work for you. Like, penny wise, pound foolish in that end. So that's something I see a lot, where people just don't really think about the forest from the trees, and they just sort of get caught up in trying to save some money here and there. And look, if you're penny pinching there, and it's something I was talking about in the breakout room, maybe it's not wise for you to invest, because when you go into investment properties, there are going to be unknown expenses and costs that come up. You're going to get fine violations, this, that, and the other, that you were not expecting, and you should be ready for it. So you should have a nice cushion and be ready for it. So if you're like sitting there like, hey, this inspector's charging $450 and this one's charging $500, and like, let me save the $50, like, and your broker's like, I've worked with inspectors, he's really better, like, use him or her. And you just got to be smart about it. So from a bad person, one of the worst things I ever saw was that, like, why you would take money from a seller to not do an inspection. And you weren't buying as is either. So that's like one of them. Not doing the due diligence for like tenancy issues and things like that, not knowing what you're getting into, not knowing the laws, or even conferring to verify the laws as it relates to tenancies and what you're getting into on that end, because then that stuff starts snowballing later. All of a sudden you're getting sued by a tenant for security deposit issue. You're like, what's going on? Wait, I have to pay this person 2 times security deposit and their attorney's fees, and I didn't really do anything wrong. I accidentally put this as an account for one day and I forgot to switch it over. Like, yeah, knowing that stuff is really important if you can, and if you're getting into it. So go ahead, John.
Have you ever seen a California investor that does not want to use an attorney? Because I had a buyer that did that one time. That was a pretty fun one.
Yeah, man. More than once. I mean, I usually have ended up, I got a lot of clients because they actually hired me for the litigation aspect, and then I ended up doing the transactions and stuff with me when they're like trying to unload the property and stuff. And like, it was nice to get messages from them after, being like, thanks, man, I wish I contacted you before I bought the property, but like, hindsight's always 20/20. But yeah, those California investors just, they're Silicon Valley people who, I've seen a lot of that, where they actually get preyed on. And like, I was dealing with the FBI and stuff and talking to them, and like, there's a lot going on in that area. And I think it's died down. It's gone through court system and all that fun stuff. But
even just non-attorney states, like I think that's why I had a California in there, because the brokers in some states, the agents will be responsible for a lot of the things maybe that the attorneys do here. So trying to explain that that's out of our purview to somebody from a different state, and they're like, "Why do I need to hire someone?" Like, well, no, you really need to. Everybody here does.
Yeah.
So that's kind of towards the end of our presentation for tonight. I wanted to open it up for Q&A to the audience here. And Bibek's awesome because he's got such a great breadth of experience, from litigation to real estate closings to, unfortunately, evictions and things like that, landlord-tenant laws. What questions do you all have for Bibek for tonight?
Have you seen anything that's either in a lease or not in a lease that gets people into trouble, landlords specifically?
Good question. So I usually what I see is, it depends on, I represent a lot of property managers, so I see where they have addendums in their lease. So when you get leases, that's why I really do like estoppel letters. Like, you want to make sure you know all the terms of that lease. So some landlords might, like, yeah, you've got your structured lease. You could have a Cook County lease, suburb lease, or you could have the city of Chicago lease. You can add addendums to it. And sometimes what people do is, like, they'll add an addendum being like, oh, landlord will pay for all utilities, or there's a modification or something. And all of a sudden you're in breach of the lease as a landlord. And you're like, you're 2 months into it and you're like, whoa, what's going on here? I thought he was paying this. He's not. And you didn't have the addendum or didn't look at it. You didn't realize that all these terms. Really, honestly, it's a familiarity with it, reading and understanding. And, like, look, I understand there's a lot going on. You don't have time. No, at that point, I counsel to plenty of attorneys. I'm not just saying for myself, but, like, it doesn't hurt to be like, hey, Bibek, do you mind spending an hour and looking at this lease? And, these are my concerns about it, or things that you're not sure about. Like, I don't know anything. Those are, that's, again, one of those things that I tell people. I'm like, it's like getting insurance. Everybody hates to pay for it, but until you need it. So when it comes to leases, addendums is one thing that I see, but really knowing the law more than anything. I mean, there's not anything specific unless you gave me a lease specifically, like, there's an issue that you can think of that you're like, oh, hey, I don't know. But security deposits, make sure you understand what's going on with security deposits. Security deposit laws kind of stink for owners and landlords. So I'm of the ilk of just, if you can avoid even collecting, you're better off. Because there's always a dogfight at the end over it too. I've just seen lawsuits after the fact over like $1,000 security deposit. You're like, well, I don't want to deal with this headache. So maybe that answered your question. I wasn't sure if it did, but
yeah, that's helpful.
Hey,
Michael. Yeah.
Yeah, I have a question. This is it's more like a retrospective. First, you mentioned something called like a estoppel paper or something along those.
Estoppel. It's called an estoppel letter.
How do I spell that?
ESTOPPEL.
Yeah, because I got kind of ripped off. I knew I had a sense I was getting ripped off on my one and only deal so far, and we asked for what the rents are and the expense, rent roll, expenses, bills, blah blah, utilities. And they send me this Google like Excel sheet that they obviously just whipped up. It was like, yeah, we're getting $1,800 times 4. And I'm like, this is the best property anyone could ever buy. And then I look at the leases, like they wait to the very end, like right before closing day or something close to that, to give me the leases. And I see that the income was nothing like what they wrote, right? Would I have had any kind of, they wound up just cutting off, writing a check, for the lies, but kind of what's the proper way to go about that? Or like,
so, I mean, exactly, you did the right thing. Look, it's a hard thing that I can, like, I can't stop another side from lying. Like, I can only ask for it and get it in writing. That's what I said. That's why I always say, like, the phone call is all wonderful, but like it's worth the piece of paper it's written on. If I got a piece of paper that they wrote and they disclosed that rent was $1,800 and the seller represented that, they gave you a lease, and then you go and you close and you're next, and then you find out the rent was like really $1,200, and then you're like, well, what the hell? You signed on, you gave me this document. Now you got a reason to sue them. You could ask for rescission. There's a lot of like, well, I won't go into that like litigation world, but
So I could sue them.
100%.
What would would it just be because they
sometimes it's just not
devalued
worth
it?
it.
Yeah.
You got to remember what your damages are at the end of the day, because you're on it's a 1-year lease, and let's say the rent was 1,100 versus 1,000, right? So it's $1,200 that you're fighting over. I mean,
Right.
you're gonna hire an attorney to sue them. You can, but like sometimes that what I tell people is like, again, once you get into litigation, which is like a whole nother world, is that that's going to start consuming your time and your energy, and is that you got to then make a decision. It's a money decision, and it's everybody's own. I'm never going to tell somebody to do it or not do it, right? I'll be like, here's your pros and cons. You have a good chance of winning, but you have not a great chance of recovering or whatever. But something that comes up with litigation, everybody gets like, I'm going to sue him and whatever. It's like, yeah, you're going to have to prepare a complaint. You're going to work with your lawyer. Then you have to answer discovery. Then you have to go into depositions. And then meanwhile, you got a job to deal with. You got a property to deal with. And it's like, what am I doing this for and for how much, right? So those are things that are important. I think Vicky, somebody just wrote a message, but they're right. Yeah, make sure you get a signed estoppel letter. If you can get it notarized, even better. But like most people don't. So.
Great, thanks.
Bibek, we had another question from one of the guests. It was about short sale negotiations. Can the contracted price be negotiated if the property conditions change? Like
probably most often not, because it's a lender who controls that. At the end of the day, it's just the lender's going to see how much they're going to get back on the defaulted loan. Yeah, sometimes they might. I'm not saying I've seen it, but generally speaking, they got a number. And it's essentially kind of like an as-is deal at the end of the day. And yeah, you can bail, you can get out of the contract. You're like, hey, this is not what I signed up for. So, that out is always there. And I know short sale contracts are also a little different. I've seen very different versions. Just make sure it has an attorney review. Like, I can get out of this if I have to, and I've got 5 days to do it or not. So, okay.
I like to call the attorney review the magic marker. So we brokers give you a napkin with a bunch of scribbles on it, and then you actually make something out of it. It's the best part. Anybody else have any more questions for Bibek here?
Yeah, I've got one last question. Sorry, Paulina, go ahead. I think I asked one earlier.
You can go.
Oh, okay. I feel bad, Bibek. I know that you're a lawyer, so you always get the questions of like worst case scenario, but that's your job, right? So like, we talked about the estoppel agreement and all sorts of stuff. And I know you can't, of course, nobody can stop anybody from lying, but typically like how, I don't know how to ask this. How common is it for people to, say things that aren't true, or to bump up their rent and to try to hide certain things about the property? Is that fairly common that you see, and does it lead to a decent amount of issues, or is that something that with the tools and stuff that you've told us today that typically is can be recognized if you do your due diligence properly?
I see what you're asking. Man, that's really hard for me to tell you.
It might be an impossible question. I know.
That's what I would say. No, it's a fair question, because I mean, like I see these. So I get contact when shit goes south, pardon my French, but like literally that you've got how many transactions. I'm not doing every transaction going on in Chicago right now. So, but I get called sometimes because of being a litigation attorney on really difficult situations. So I see the bad ones, but like there are how many transactions going on a day, so it doesn't really come up. So I would say it's probably pretty minuscule that it does happen, or it's pretty small, but sometimes you got to go with your gut a little bit. You're like, oh, something doesn't smell right here. you'll know. You'll know. You'll be like, oh, they're really like dragging their heels getting me this estoppel letter. They're like, oh, the tenant doesn't want to sign it. Oh, there's like, so things are going to kind of tip you off. If somebody commits fraud and they sign on behalf of the tenant, it sounds like I never signed that. Like, that can happen. I don't know. I don't know what the tenant's signature is on a lease or on an estoppel letter, if that's their signature or not. So does it happen? Yeah, I'm sure it does. But then it's like, what is it worth going after that person?
Awesome. Yeah, that kind of is an unanswerable question, but I
totally I don't know. I mean,
sounds like due diligence.
I have no percentage. I have no idea.
Totally, of course, yeah. It sounds like with the due diligence, we should be able to, if we do the things you suggested, should be able to sniff out most of it, and then just paying attention to behavior and strange things
and the
stuff.
brokers. Your brokers are, he's John, like he knows what's going on. He's got the pulse. Like he knows, he talks to all the brokers. So it's not like we're not the only people involved in your transaction. You've got the other broker, you've got the seller's attorney, you've got the seller, so that when somebody's hiding behind the ball a little bit, like you kind of get that feeling. Like if I'm on a deal with John, I'm like, man, John, I got this like weird response from the seller on this. I want to give a call. And he's like, this broker's been shady from the beginning. Like, that they'll tip me off. That's something we'd tell the client and be like, hey, they're being really sketchy about this. So maybe we might want to rethink this.
Awesome. Super helpful. Thanks.
Yeah.
So I had a question. So do you think at some point it's just really worth asking for a security deposit if it happens that you actually will need it? Why? And there's usually a fight about it. Can you just ask for a move-in fee? And
yeah, so you're going on a pretty. I could take you down on a pretty big. Like we could spend like a couple hours on this, so it depends on jurisdiction again. First, there's laws about secure deposit. I'm not giving everybody here legal advice, by the way. I should probably put that disclaimer out. Like, it's all case by case basis and dependent upon your situation. Look, if you know what you're doing, you understand the law, your risk, there's no reason you can't keep a secure deposit. I say it from the perspective of, I see the ones that get litigated. And so I see the headaches that come with it. And sometimes it's like, you're looking at nominal dollar figures possibly. Or is that security deposit worth it? And they're going to hire an attorney to fight over it. And then you find yourself dealing with it in court and you're just like, this is pointless, over $1,000. And now it's just sucking up my time and energy. And, moving fees, fine, definitely, check what the local requirements are for moving fees, because again, the law as it is, let's just say city of Chicago, the way the courts look at it, like what people started doing was just relabeling security deposit into moving fees, and somebody got burned. The court said, well, that's still a security deposit and you violate all the security deposit laws because you just renamed it essentially. So they essentially set some kind of bright line rule essentially in terms of what really constitutes a moving fee. Even more so now it's Suburban released. You got to really state out what is that movement, administrative costs, this, that, and the other, and like really label it. So it's a lot harder to do the moving fee because everybody caught on to that. So, you got bad owners and bad landlords also, and that's why these laws are created. It's not for the masses; it's for the bad actors. And unfortunately, the good people get stuck with these rules, and then they get burned by it because they end up not knowing really what's going on, what they should be doing with security deposits. So I was saying earlier, like, if you can avoid doing security deposits, you don't want a headache of it, then like, don't do it. And if you don't understand what you're doing, you don't trust yourself to be able to handle it. All right.
All right. Mm-hmm. Thanks.
Let's see, does anybody else have any other questions? As we kind of round out the.
I think somebody wrote a question or somebody wrote something. I saw something on the chat.
Yeah, Vicky May said moving fees are not allowed in most of the county outside of Chicago. Some exceptions exist.
Yeah,
About
I don't, that's not necessarily accurate. Well, Suburban Cook County has a breakdown sheet. You just have to fill out the form in the breakdown sheet that's attached to it. Again, if you can delineate what the move-in fee is for, like if there's an administrative fee, yes, you can do that. You know, there's a pet cleaning fee or something like that. You know, you gotta be, yeah, it just, yeah, I think so. It can't be like a security deposit. That's correct. I don't know. That's Vicky who's writing that, but yeah, if it acts like a duck, quacks like a duck, it is a duck. So if you, that's how the courts are going to look at it, and they're going to say, "Oh my God, you've got $1,000. You used to have $1,000 security deposit. Now you have $1,000 move-in fee." Like, no, you're going to get burned.
I think all of this, in my opinion, as we kind of wrap up here, just highlights why it's great to have a good attorney on your side, not just when you close your transaction, but also if you need to manage your property, because lots of questions can come up later on, and you can be in a world of hurt if you don't have the right people giving you advice. So, free commercial for you there, Bibek.
Thanks.